Welcome to another Fireside Chat. My name is Irwin Oostindie. I'm the president of the board from the Wild Bird Trust of BC, and just want to thank you for taking a bit of time with us to delve into some issues that are really dear to us. And we have a very special guest on this month's Fireside Chat, and it's Jeffrey Nicholls. Good evening, Jeffrey. I guess I'm sitting in the dark, but you're sitting in the daylight, so.
Yeah, hello. I guess I'll take a moment to introduce myself. So my name is Jeffrey Ryan Nichols, and I'm a Gunhada clan member of the Tsimshian First Nation, proud Lakwalams band member. I'm an associate lawyer at Ratcliffe and Company, which is a law firm on the North Shore. I practice in the area of Aboriginal law. And I'm also the current board president of Raven Trust. And I'd really like to thank Wild Bird Trust for reaching out and inviting me to join in this session. I'm really excited to participate in this format. It's not a lecture, it's not a presentation. It's just sitting down and talking through things that might be on our mind, and I really appreciate that. I'm joining today from the territory of the Musqueam, Squamish, and Tsleil-Waututh peoples, and I'm really grateful for that. I make my home on their territory, and yeah, with that, I'd love to sit down and chat.
Good. Yeah. And we both serve in leadership roles for our organizations. And I think that's something that'll perhaps come out from our not necessarily about our roles, but about the kind of visions that we, I guess, co-locate between our organizations, but also the kind of visions that we share with our own organizations. So we're going to unpack that a little bit today. I'm a Dutch settler. I grew up in Tsleil-Waututh and Squamish territory, and that's also where one of the areas that the Wild Bird Trust of BC caretakes, which is Maplewood Flats. And a lot of people think about our organization as that particular site that's next to Tsleil-Waututh Reserve Number 3, Burrard Indian Band Reserve Number 3. When I grew up, that's what it was referred to, and so. We do caretake that site, and we're in the process of redressing that site to Tsleil-Waututh, navigating the colonial and crown instruments, the kind of administrative colonialism that surrounds that site, the Port of Vancouver, Environment Canada, and I think that is exciting with the Wild Bird Trust of BC and Raven Trust, is that both organizations are really interested in these questions of Indigenous sovereignty and thinking through what we do. Around how do we address the issue of the climate crisis? How do we address the issue of people trying to do right, participate in solutions? And Raven Trust, Jeffrey, is really inspiring for me because its commitment, its understanding of that kind of intersection where Indigenous law, the land, sovereignty issues are right front and center, and inviting settlers to participate and pushing that forward as allies and as accomplices. So that was my perhaps introduction of Raven. But do you want to give a little bit more context to Raven? I know you have an organization with an ornithological name, but in fact it's much broader than birds.
Yeah, so Raven stands for Respecting Aboriginal Values and Environmental Needs. So it's an acronym, and then it's kind of funny, actually. It's a little bit of a insider secret. So trust is in our name, but we're not legally a trust. We're just we're a society. But what we do, and I think that taking a moment to provide some context or background on Raven, I think would be helpful for the conversation. And I think so. First and foremost, Raven was founded as an access to justice organization for Indigenous people. So, I think for a lot of historically marginalized groups, obviously, access to justice, access to the court system, lawyers, very expensive. The laws that that we use to adjudicate disputes are often quite foreign to, in particular, Indigenous legal orders. It's only been recently that we've seen Indigenous legal orders start to make their way into these forums. And also, we can probably get into a bit more detail later about this, but I think that in Canada in particular, the trajectory of the judicial system as a method for achieving justice for particularly Indigenous people has been I mean, it's always mixed when I say this, but I think that overall it's certainly marched towards justice, perhaps more so than other forums. You know, we have the Supreme Court of Canada laying down landmark decisions about Aboriginal title, about Aboriginal rights, interpreting Canada's constitution. We have Section 35 in Canada's constitution, which recognizes and affirms Aboriginal rights. The courts also interpret treaties, which have constitutional status. And so we've seen a lot of instances where court decisions have like been make or break for certain key priorities or events in the relationship between Indigenous peoples and Canada. And so I think that's where really Raven lives, is we're laser focused on, I know that, you know, like in some of our board deliberation, you know, the project of justice is very large, and you know, you can go in many different directions with it. But I can share in quite a candid fashion that you know, our discussions at Raven are laser focused at really this this method of, you know, we raise money. Public education is a big part of it. So there's lots of different components. We run campaigns that are linked to specific initiatives and court cases, obviously. And we support Indigenous peoples to assert their rights in court. And so that kind of gets, so the access to justice umbrella, you know, what I just explained is kind of overarching, but the two components underneath that umbrella are, you know, like what we might call decolonization or reconciliation or assertion of Indigenous you know, rights and title, Indigenous legal orders, that component. And then there's also an environmental justice component. So when we have this kind of twin mission, I think the Indigenous one comes first, but they're obviously very linked in our work, is all our campaigns have these two threads that come together. So yeah, and that's basically what we do. So a very notable campaign that we've done is around the Trans Mountain pipeline. We ran a pull together campaign, and I understand, Irwin, you were quite involved, you know, with that, and you know, in a really big way. And I think that you know, we saw the effectiveness. Maybe not, you know, probably the book isn't yet written on it, but we certainly scored quite a victory when the Federal Court of Appeal struck down one of the permits for that process, and then it was remitted, and more consultation had to happen, and that kind of thing. You know, these are obviously, and of course the Gitgatla decision around Enbridge Northern Gateway, that was supported by Raven as well. These are the kinds of things, you know, that we support as an organization, and so that's kind of on the court side. But Irwin, what you were talking about was, you know, the involvement of everybody, right? It really takes a broad coalition in order to make these campaigns happen. And I think that really is where the magic of Raven is. So it's in the courtroom. It's, you know, fighting. We've been very successful in supporting campaigns. Not that success in court is a measure, because sometimes, you know, the fights that most need to happen, you know, might not be winners in today, but they might, you know, set the bar for later. So I just want to kind of make that clear. But on the campaign side, we really, you know, we have tremendous staff at Raven that really organize and really empower people to like run events in their community, really, you know, just get involved and ultimately help the cause. We're primarily a fundraising organization, so we don't do much else. I mean, we have a public education component that I always stress. Like, we run social media, we have lots of great resources, and we educate people along the way about what we're doing. But primarily, we're a fundraising organization. We're there. How I think our vision of decolonization is very material. You know, we want a material change in the relationship of power, and that involves you know, flowing resources from, you know, the collective, people who care, people who understand the importance of our work, and putting them in the hands of Indigenous groups who choose to use those resources to assert their rights in court, and ultimately you know, move the bar forward on Indigenous law, and also move the bar forward on this kind of twin purpose. Often the campaigns we support have a strong environmental justice component to them.
And there's an interesting thing that when you talk about this kind of iterative process of decolonization, you know, and it's hard for folks who are younger to recognize that there is change, and it is slow. It's not as fast as we want it, but I think in this time and space, Raven is the right organization for this time, because what it does is it affords a system where settlers and migrants can actually strategically engage in the right way. I mean, there's ways, I know there's some people watching this that are on the front lines on the TMX issue, and there's different front lines that people are on, but the broad swath of the public, either are working, they're busy in their families, they're busy in their communities, and they may not have time to do frontline work. But it's really easy for them to, for example, donate a day of their wages each year to Raven to kind of advance these larger questions that are underneath our society, right? So it's easy for folks to get busy, to think about, oh, there's climate crisis, or there's a particular environmental issue over here or over here. But in fact, I think what we're going to talk about today is really looking at the underlying issues and the underlying solutions that are apropos at this time and place. So I think about back in 30 years ago when we were talking about reconciliation and redress, or Bruce Clark would argue that in court, he was laughed out of the court. The Vancouver Sun had a photo of the lawyer for Gustafson Lake with his, his bald head and his artsy glasses. And they were basically saying, this man is crazy. He's talking about some royal proclamation of 1763. And the Vancouver Sun editorial and the RCMP and the NDP government, mocked that legal principle, that in fact, British Columbia is almost entirely unceded. And so here we are 25 years later, it's a generation later, but we actually do see a sea change. And reconciliation is generally performative. I really caution folks to avoid the reconciliation bandwagon, specifically. Like, I think that's an appropriate language for it. To really focus on redress, because redress is about, as Pam Palmater says, redress is the kind of fluff. Reconciliation is the fluff. Redress is actually the issue of land. It's the actual issue of power, of resources. That's what actually we need to be doing. And Raven is a system where people can actually support tactically work that Indigenous people are doing to defend and protect the lands that they've stewarded in some cases for thousands and thousands of years. And tell us a little bit more about, I know we're going to get into birding and a whole bunch of other issues, but you mentioned TMX. There's a few campaigns that you're working on right now, and one of them, in terms of birders and wildlife, it's easy to talk about Site C as this kind of like existential kind of like hypocrisy of modern day capitalism stewarded by a social democratic government, on one hand claiming that they're opposed to it, and then it's no surprise, of course, the premier who said he was opposed to it and then changed his mind is also the premier who on Earth Day 2014 sabotaged Adrian Dix when in Kamloops Adrian Dix declared that the NDP would oppose the TMX pipeline. The very next day, John Horgan is meeting with Chris Anderson, the president of Kinder Morgan, to say, no, it's okay. Or that day where you were talking about when Tsleil-Waututh were announcing that they were taking Canada to court over that crazy NEB process over the TMX pipeline in the Westridge terminal, John Horgan, just 2 kilometers away down at Lindterm, was having a photo taken for the Vancouver Sun right in front of pipeline pipes, just as the Tsleil-Waututh were announcing their opposition. So there's a lot of, it can feel very bleak when you think about Site C. But I think what Raven is doing is saying, yes, there's environmental issues, but there's a bigger issue. And maybe, Jeffrey, you can talk about what's that bigger issue for the West Moberly?
I think that perhaps, what I take most from that. So you're speaking about, so we're supporting West Moberly First Nation in a civil claim related to Site C. And a lot of the campaign materials and that kind of thing are accessible on our website, and people can learn more about that specific campaign. Perhaps I'm probably not the most well-versed to talk about some of the ins and outs of their legal claim and that kind of thing. But some of the overarching themes, getting at those kind of first principles, is like you mentioned, the role of various politicians and that kind of thing. Like, you provided a good overview of some of the political discourse that surrounds a lot of these issues. And I think that one of the benefits of a judicial process, and don't get me wrong, courts are absolutely political forums, but they're not kind of partisan political in the way that we might think of a lot of these, other kind of institutions of government, at least in Canada and in the Canadian state government. So I think that where Raven engages is, I talked earlier, and you referenced it, was making a change in the material relationship of power. That's ultimately actually how I define, decolonization. Is, there's a lot of and some of that is valuable, and some of that is, as you say, fluff, and we can kind of, it can be difficult to discern. But I think where I really boil it down, at least for myself, is are we making a real change in the relationship of power? And with the judicial process, as flawed as it is, and with all of its blemishes, and we're still ultimately dealing with a Canadian court system. We're a long way off from having an Indigenous judiciary that's recognized. I mean, we can envision that in the future, but taking what we have right now, that court process is judges make the law. So when a judge hands down a judgment, that's the law. And in some cases they follow legal precedent, but in other cases they make slow and incremental changes. Irwin, you mentioned that this process of slow and incremental change, and the degree to which that slow and incremental change in the legal system has influenced the political system is, in my view, immense. We see, for example, Aboriginal title. So the earliest Aboriginal title case, some people debate about this, legal scholars may debate about this, but we'll say that the earliest Aboriginal title case is St. Catherine's Millings. And it occurred, I believe, in, I'm going to get it wrong, I should know this, but it occurred a long time ago, over 100 years ago. And then we have Delgamu in 1996. I skipped one, Calder in 72. And then we have Tsilhqot'in in 2014. And you see this trajectory of slow and incremental change towards the first declaration and recognition of Aboriginal title. And it's not the source of Aboriginal title, because of course, us as Indigenous communities, we have our Aboriginal title. Like as a Tsimshian person, we have Aboriginal title. We have our actually Tsimshian title, a co-Tsimshian title, and it's defined in a court historical and legal system. But as far as this process of changing the materiality of power, we're now in a situation where, and again, it's a long way off, but there's some actually fairly important government policy that is poised to, where it would be unheard of, even at the beginning of my own legal education. And I'm taking baby steps on my career, but some of the things that I see in my career is just even unheard of for that decade. And to think that we've gone this far in this period of time is really quite remarkable. So I think that those are some of the first principles, I think, where Raven is engaging. To summarize, we're talking about the judiciary, which is kind of insulated from a lot of that, because, like you're saying, there's politicians that, go here and there, and there's elections, and a lot of this too is, we can talk about how, Indigenous peoples are wrongly seen kind of at the whim of public opinion, and that public is defined as, this kind of large, like Canada. We've seen, like, what does the public think, or maybe a bit further back, like, what does the taxpayer think? Like these kind of very antiquated concepts. Whereas I think,
or the
in some way,
rate pair is the other term.
Yeah, and in some way, the judicial process is, and again, it's imperfect, because you can critique this, but the judicial process in some ways is quite insulated from that. We have the Constitution, which is the supreme law of Canada, that recognizes and affirms Aboriginal rights. And we've been making inroads. The degree to which Section 35 has really changed the landscape of Canada has been immense, because that flows into the conduct of, let's say, private companies, right? We're in situations where many groups in industry are just simply asking, what can we do? Right? Like they don't really have, like, they want to be able to do the right thing, but they just, and that's even unheard of, right? They want to be able to have a path to do right. But there's, again, lots of there's lots of moving parts and that kind of thing, but a lot of progress has been made, and much is still to come.
Now, we talk about these different situations of legal fights where First Nations are taking Canada, taking the province to court to have their unfettered rights acknowledged, or have Crown's own rules used fairly by the Crown. We also have a history of the Crown losing in court, or the Supreme Court making a declaration, Dalgamuth, Silcotin, etc., but then almost immediately then litigating 1 millimeter from the distance of the victory or the defeat. Can you say a little bit about that briefly, and then how that might have implications for environmental work, or kind of like the fact that there's so much always going on, at one point is there peace? We've seen the examples with like Cindy Blackstock, taking the Liberal government and the Conservative government to court over their handling and their unfairness around how they treat Indigenous children versus non-Indigenous children. Are there similar parallels around the whole issue around stewardship, land defense, wildlife protection, where we can kind of look at the courts as a battleground that seems to kind of be perpetuated by Canada?
I think the courts are absolutely, a battleground, kind of in a colloquial way, right? The courts are an adversarial system, so you have two or more parties that are on either sides of the the issue. So that's of course that's an institutional choice. There are other ways of structuring decision-making process, or even a judicial system besides that. But certainly in Canada, that's how things go. And so there has been instances where I'm not too close to this issue, so I can't speak very closely to it, but I understand that a contentious issue, there was a litigation directive that was issued by Jody Wilson-Raybould when she was at Justice Minister. And it said a couple of things. I don't know many of them off of memory, but it basically, it was a message to government lawyers that said, hey, you can't make this and this argument. We're beyond that. These kinds of things are offensive, and maybe just because you can in law doesn't mean that you should, right? And we should kind of leave those to the past. And I think that, and again, I can't comment. I'm not on that side of the fence, and but I think that
2018, 2017.
Yeah, and I understand that that's still in play, and I know that there's lots of discourse perhaps in, maybe it's just limited to the legal community, but I know that it hasn't been smooth sailing. There's been instances where it hasn't always been followed. There's a concept of a fiduciary relationship in law, and I'll save the kind of legal jargon to a minimum.
Mm-hmm.
But it basically, the Crown is a fiduciary to Indigenous peoples. Where the Crown makes decisions that affect Indigenous rights or Indigenous peoples, or where they take that position of power, rightly or wrongly. I'm not going to comment on that. They have a fiduciary responsibility to consider the interests of Indigenous peoples when they take that kind of power, make that kind of decision. And it's interesting to think about how that reconciles with an adversarial court system. So if you have agents of the Crown in the court system, they are members of the bar, and they're sworn to certain traditions of the legal system, just as I am. I'm a legal advocate, and I took my oath, and my signature's on that 120-year-old roll. Like there's lots of traditions in the practice of law, and it's interesting to think about. Some of them are in tension with each other, because if you're in an adversarial court system and you're representing the Crown, and the Crown has this fiduciary relationship to Indigenous peoples, how does that play out with an adversarial court system? I don't have the answer to that question, but it's certainly it's a question that comes up in legal ethics about how do you represent, like how does the Crown represent itself in these kinds of debates? Because I would want to say, schools of thought out there in you use a big word like legal theory, for example, but I would just say, when discussing Canada's constitutional tradition, that says that, Indigenous peoples are just as much part of Canada's constitutional framework as any other group. Canada's a federalist system. We have provinces, we have territories, we have treaty First Nations, we have all sorts of different, we have Quebec, and Indigenous peoples, in my view, are a part of that system. And so there's lots of interesting things that comes out of that recognition. And again, the book isn't written, but these are the kinds of inroads and thinking and structure that we're dealing with.
So if we can go just a little bit farther, and then we'll switch topics. But
Sure.
I'll introduce a couple terms. One, Indigenous law or Indigenous knowledge, and then
Sure.
terra nullius assumptions. So if you said speculatively, we'll have an Indigenous legal system at some point, parallel perhaps. We're getting more and more of that, and we're getting instruments now and smaller systems that are more sensitive and responsive and available to Indigenous communities in particular. But there's this kind of, and I think Russ Diabo and Pam Palmutter and Judy Wilson from Nisconawith on one side, and then Jody Wilson-Raybould, who you mentioned, maybe on the other side, on this notion of Indigenous law and Indigenous knowledge on top of Canada's rights versus underneath. And I think just for our viewers, how can you just speak to that briefly, and where are we at with that potentially shifting? I know it's a very political issue. Jody Wilson-Raybould was obviously recruited by the Liberal government for a reason, and it's not lost to me that Liberal government, operated colonialism for 152 years before they recruited her. So maybe I'm showing my cards too quickly there. But there's this thing that a lot of folks don't necessarily track, which is this terra nullius assumptions and this kind of Indigenous knowledge, and how in many cases Indigenous knowledge is not understood and respected by the court. And what Tsleil-Waututh did was rather spectacular in the way that they said, yes, we have our own ability to represent our needs. We have our own ability to do environmental assessments of these industrial projects, and they did it, and they were one of the first Indigenous nations to do that within Canada, and say, yeah, and when they went to the NEB to say their declarations of their knowledge, all they said was, Gabe George went and just spoke the origin story of the Tsleil-Waututh, of being from the water from where these increased tanker traffic would take place. So very, very, very smart, very appropriate response to the Crown to say, we're here because our rights are limited. We will engage, but we're going to engage on our terms. And so I think for me, that was kind of exciting because it really questioned those assumptions of, is Indigenous knowledge valid within the Canadian court system? And what are some examples where, we can kind of see that playing out, and questioning, does Canada actually have rights? When in fact, to Bruce Clark's argument from 1995, that there's these historical mistakes that have been made by Canada and British Columbia. And we're seeing UNDRIP being brought in, and activists are quick to say, well, as soon as UNDRIP is brought in, and then the NDP are knowingly sending in the RCMP to Wet'suwet'en territory. So, these kind of glaring moments of time. We think we're making progress, but then we're still over here. So I think it's helpful to acknowledge that things are changing. But
Certainly.
Sometimes it's hard to know where the front line of that change is taking place.
So of the three terms that you mentioned, I think I'll take up the second term first, which is this idea of Indigenous knowledge and how it's addressed in the court system. And so, and really, I have to kind of put the little asterisk beside that. This is, what I'm about to say is quite limited and specific to the court system, the Canadian court system. And so, because there's lots of obviously different ways that people understand, what Indigenous knowledge is, and even kind of that term can be problematized because there's like many different kinds of Indigenous knowledges. Yeah. I think one of the more interesting aspects to that in Canada's court system is, and it relates, I think, I'll tie it right into Raven's vision, it relates to Indigenous people's voice in the court system, right? So, this idea that, I should preface this by saying that, up until the early 50s, Indigenous peoples could not hire lawyers to pursue the land question in court. It was illegal. You could go to jail, like that was in a federal statute until, the early 50s. And that's really near and dear to my heart as a practitioner at the bar, is that it's not lost on me that my clients, the First Nations that I represent, could go to prison within some of the living memory. Some of the people that I work with were alive in the 50s, right? And so within their living memory could go to jail in order to do something that we now do today, have a solicitor-client relationship. So that, I think, is it's always front and center in my practice. And so I kind of took a little detour, but the Indigenous knowledge piece, there's lots of contestation around this idea of having, what is Indigenous knowledge and how does it count as evidence in the court? So there's two thresholds. So the first being even getting in the door as evidence. So being able to establish a fact, that we harvested berries in this location, right? Like, how do we establish that fact? Forget its legal significance, just how do we establish that? And, if you're an Indigenous group and you have an oral tradition that says, that maybe we have a supernatural connection to that area. I'm going even a further level just to say that, oh, my auntie told me that I could, which is, hearsay in court. So, inadmissible, getting told by someone else. It's just, there's lots of barriers in evidentiary rules for Indigenous knowledge to get accepted as fact. Now, there's been a sea change in that area. So through many, I'm sure, many people wrung their, there was a hard fought fight to get this, but there's been inroads to that. And so now,
in particular, Delgamuth and Gitsanwet.
That's correct.
Admissibility of oral history and.
Yeah, and the Supreme Court of Canada in Delgamuth took the extraordinary step of overturning the trial judge's finding of fact. So normally, there's a trial and the trial judge takes care of all of the findings of fact. And then on appeal, it's very rare for appeal courts to consider evidence. They consider the record of the trial judge, but they don't hear new evidence and that kind of thing. Sometimes it happens, but it's very, very rare and it's extraordinary. And then for the Supreme Court of Canada to do that is not that they necessarily considered evidence, but they took issue with the findings of fact, which is very unprecedented to my knowledge in Canada's court system. And you're right, that was the Delgamuth decision. And that really kind of shook a lot of things loose on this question. And that, so this will be a good segue into the next term. So Indigenous law is, so that little conversation was just relating to evidence, right? So establishing facts that would support certain claims. That's not at all talking about legal claims or legal submissions, interpreting the law, right? What actually is the law, which is separate from evidence, right? Like, evidence is here, and then, the law is how we apply the evidence and articulate what the law is. And that's the role of, obviously, Indigenous law. Indigenous peoples, I can only speak, well, actually, I can speak from my individual knowledge of, I'm certainly not, I couldn't speak for, my whole nation, but I understand the laws that I've been taught. And certainly the Coast-Tsimshian people, we have a very sophisticated legal system that is, when I don't like telling it from this perspective, but sometimes it's entertaining, is, when they first sailed the ships and the first settlers were coming in, they wrote in their journals that they were so disappointed that, every single inch, every single bush, every single fishing hole was owned by someone under, the entitlements through Indigenous law, because, we knew who owned what. And you can look to Delgamuth, it's obviously a different nation, but you can see some of the comments about, and not that sophistication is also indicia of existence of law. You can have, because that idea also is, sometimes it can be quite racist, is this idea of complexity, because that's been used against Indigenous people, is the fact that, well, the Western system or the colonial system is, it's so complex, and so therefore, right, it's used to justify oppressing Indigenous people or marginalizing Indigenous law. So I guess I haven't defined, I can't define Indigenous law, obviously, but its role in Canadian law is, I explained a bit of that earlier. It's my view that, Canada's federalism, supports, sorry, I just saw a change in view there.
Yeah.
Canadian federalism supports the multiple jurisdictions or authorities having power, right? We have different provinces, we have different groups of people, local governments, provincial governments, federal governments, and it makes sense that Indigenous peoples can fit within that sphere of federalism. And I would argue that principally through constitutional recognition and through just merely the fact that they exist. They exist on their own terms, completely separate from anything to do with Canada or British Columbia or any colonial institution. Indigenous laws just exist on their own terms and govern within Indigenous communities, and have done so for a long time, but have been disrupted through colonization. So, through residential schools. I think of the way, perhaps I'll kind of transition out on this point, is, in my community, a lot of the way in which law is taught is through your family. You learn things through specific individuals, actually. The way of kinship in our society is very well delineated. You learn certain things from your mother's brothers. You learn certain things through your mother's sisters. Your father's family, they have certain obligations to you. Like they're all very specific. And so things like residential schools, separating and destroying the bonds between families, in particular, is incredibly disruptive. And a lot of our laws and our language, so Coast Shan people, we speak Somaliac, and perhaps when we talk about birds, I can bring in a few Somaliac terms. But that's where our law exists. It exists in our Adao, which are oral traditions. And those are perhaps the most vulnerable when you have a system of genocide that has been recognized as genocide in the Truth and Reconciliation Commission. It's been recognized internationally. It's been recognized by Canada's former Chief Justice. That's not up for debate. And so, these systems have really wreaked havoc on the operation of Indigenous law, but thank their creator that they weren't successful. And certainly in my practice, I'm constantly looking for ways. And, everything that I do is all like, how can I kind of move the needle on creating more Indigenous law content that's kind of separate from maybe perhaps Western traditions or the colonial law.
And I think just to kind of shift from legal questions and legal principles to land and birds and things, I think sometimes when I think about that particular site in so-called Broad Inlet in the Tsleil-Waututh, in the heart of the Tsleil-Waututh territories, which is where the Westridge terminal is, which is the kind of the western end of that TMX pipeline route that they want to expand. And to your point, that they were even unable to, when you think about the Coldwater, the Coldwater was paid, I think, what, $2,000 in 1953 for this pipeline to go through. And it was just like the band manager who approved it. Nobody else was asked their opinion. So it's kind of bleak and eye-opening for non-Indigenous Canadians to realize that, to your point, Indigenous communities they were barred. They faced the BC Penitentiary, Ocala Prison. That's what they faced. That was their system of access to justice. So how now, here we are, this notion of the equivalency of access to justice and access to land. And I'm asking that question because I'm interested in stewardship. I'm interested in folks think about saving birds or saving grizzlies territory, but this notion of like, how does access to justice and access to land, how do those two things come together?
Well, I think that to transition into birds a little bit is birds are so closely connected to the environment in which they inhabit. That's one thing that is really remarkable for me about the hobby of birding. I'm an avid birder myself, and it's really given me a really, I would say, a deeper perspective on the world that I walk in, because the birds in some way are kind of wayfinders, right? Like they have their specific things that they like, or environments that they like, and you can walk down and through these different environments, and you can really tell where you are in space by what birds are around and what they're doing, and you can tell the seasons and like everything. Like you can tell a lot about the place through the birds, and I think that in some ways is connected to this idea of indigeneity. It's connected to it's a place-based identity, right? It's rooted in the land, and a lot of the aspects of, in my view, all of this is just my own opinion, obviously.
Hey,
and
we're just having a fireside.
That's exactly right. That's exactly right. And so, in my view, a lot of the conversation around, at least as I've been a part of it, around protecting, in particular, birds is linked to broader projects, obviously, of environmental protection, right? Like in order to actually successfully, I'm not a biologist, but my understanding from a layman's perspective is in order to understand, in order to protect the habitat of birds, you need to protect all sorts of different things around it, right? I think that your organization, I think, has been involved in some of the advocacy around Roberts Bank Terminal 2, the expansion. And I'm on the outside of that, and I've just kind of seen from what I can tell, it's in order to actually protect that habitat for those shorebirds, is a very they're so deeply entrenched in the environment, and that's obviously kind of on the stewardship side, and thinking about their relationship, but just from kind of a person myself, being a part of a larger environment, when I'm walking through, taking everything in, like what do we look for the birds for? It's a signal. You have that relationship to them, and that's probably one of the most rewarding aspects of birding for me, is getting to really I feel like I really experience a place when I bird in that place, right? Because the birds show you what is there, and it starts getting into my partner Siobhan. She's really into the plants, and and that just it all kind of just snowballs into we're learning about all the different plants now, but it's like, oh, those are this kind of berry, and we can expect cedar waxwings in there, and you better be watching the cedar waxwings to see if there's a bohemian in there, right? You want to get one check for the list. So it's kind of this snowballing process, and I think that that really ties into some of the broader themes about these bigger conversations about how we protect the environment. And I think that the last thing I'll say on that is I think that it's telling that one of the most powerful pieces of environmental legislation in Canada is the Migratory Birds Convention Act, because birds, they're everywhere. They're under the water, they're on the surface, they're in the air. They're quite ubiquitous, and so that has implications. It has implications a lot of different ways, but one of the ways it has implications is obviously the legal framework in protecting the environment and protecting the birds, which I think is super important. But it's like a chicken and egg kind of situation, quite literally.
Yeah, and there's often a situation like when you think about Site C, the number of the threatened species it's a huge list.
Yeah.
Barn swallows, species at risk, warblers, the common nighthawks, flycatchers.
Yeah.
And then then you go down into the blue lists, and so it's often a situation where people are litigating, environmental justice groups are litigating on a particular species, but in fact, Raven doesn't litigate for a particular bird species. It litigates for Indigenous rights, and I'm thoughtful when I think about and I have conversations about Maplewood Flats, because it's an area that we have jurisdiction over, quote unquote. Yep. We had jurisdiction, and we claimed that Tsleil-Waututh Nation did not. And in fact, in our management of the site, we did not engage Tsleil-Waututh. And so, that's that just seems bizarre, because what one requires to have that analysis is that there's a glass wall that somehow the birds don't fly up against between our jurisdiction and
Yeah.
Tsleil-Waututh Reserve or the traditional land. So it's remarkable how important these issues of Indigenous knowledge is. And to your point, we don't talk about it as TEK, traditional ecological knowledge, or Indigenous knowledge. If we're talking about Maplewood Flats, we're talking about Tsleil-Waututh knowledge. Right?
Yeah.
So when Gabe George was speaking to the TMX, to the NEB process, he wasn't talking about Indigenous worldviews like some pan-native,
Sure. Yeah.
ideal Indigenous, as a lot of white folks, in particular, white settlers, often think about kind of romanticization, or we have these kind of stereotypes of, Europeans romanticize of the Native Americans. But specifically to your point, that the knowledge of Burrard Inlet, as epitomized by, for example, Elder Iggy George, who passed this year, who knew intimately the currents, and who knew intimately, if there was an oil spill, where that oil would flow. And yes, an environmental group could do an analysis around with floating digital markers and track the currents. But you could also ask Iggy, right? Because he'd canoed those waters for 7 years. So I'm fascinated by this notion of how we can protect birds through restoring habitat that only birds will enjoy. Your thoughts on that kind of provocative notion of, like, yes, in industrial wastelands, prone to kind of decades of environmental racism, we're going to create a nice little area over here for the birds.
Yeah, I think that there's all sorts of, like, I think you get into this is less my area of expertise, because sometimes I've seen quite complex schemes developed by biologists that are quite opaque to me, that are at least in outcome designed to support very specific aspects of an environment that might be completely decimated by a proposed activity. And I think that
there's a 2 years of budget, and then after 2 years, we don't know who's paying for it.
Yeah, and again, I can't comment on the efficacy of any one of those particular things. I'm not a biologist, and I don't, quite frankly, understand a lot of that stuff. But like, for example, I've seen examples where they wanted to, for a specific project, for example, they wanted to, like, take out a whole bunch of eelgrass beds over here that are thousands of years old, and we don't fully understand how they were created, but we know that they're very sophisticated, and they support a salmon run in the tens of millions. But in order to mitigate that, we're going to develop very specific kind of, like, we're going to use the dredge and silt to develop these kind of other islands and things like that. And I know that in that particular example, my community was quite skeptical of that, because it's like, there's no proof of the efficacy of that. There's no proof that with the currents, those will even survive. There isn't an island there already. The sediment doesn't accumulate there. It probably won't stay there. And what's wrong with the eelgrass beds that are there already? But again, I'm not a biologist. I don't know about those things, but I can speak generally to the approach where, in my view, at least from that Indigenous knowledge and Indigenous law perspective, what I've generally seen is Indigenous law is oriented much more holistically. So it's oriented more towards perhaps protecting the entirety of an ecosystem, and it's not sufficient generally, according to the Indigenous laws that I've discrete Indigenous laws that I've been familiar with. There may be others, who knows? I don't know, but at least I haven't seen one that isn't kind of more holistic, and it's not appropriate to just kind of design these very specific mitigation mechanisms where you get these kind of Frankenstein ecosystems, where it doesn't seem natural to me. So yeah, perhaps maybe that's what you're speaking about, and that's some of my quite candid thoughts about that. Is that you get these kind of weird, where you're talking in a hotel boardroom, between kind of bureaucrats and advocates and all sorts of and biologists, people that are, I'm not in a position to comment on whether or not they're qualified. They might be completely qualified to talk about these things. But it's certainly, in my view, pretty far removed from actually kind of a lived 1,000-year-old relationship to the land, where you have these elders or knowledge holders going, that isn't going to work, or we want it to stay just the way it is, or in fact we want to enhance it because we might be talking about something right today and now, but hey, 50 years ago there was this like massive disruption that occurred and that still hasn't been fixed. So that happens quite often because we have a legacy of lots of environmental degradation in Canada that needs remediation. So yeah, that's a bit of kind of a framework of sometimes what goes on.
Yeah, and there's a lot of the biology work is actually in offsetting, right? So we have, again, industry and government love to kind of look at these situations on a case by case basis and not look at cumulative impacts. And it's just like
Sure, yeah.
it's just this, if we're not looking at cumulative impacts, if we're not looking at like the fact that the lower mainland, the Coast Salish region here, it has been turned into kind of a major international carbon export zone without ever any referendum, without any ever consultation with all the local nations, and said, does the Port of Vancouver have the right to do all these these projects and then simply offset them? We'll throw the birds and the salmon and the orcas under the bus over at Roberts Bank because we think we can offset it in this way, regardless of the fact that there's increased ships. So those orcas will, there's cumulative impacts on the whales, there's cumulative impacts on salmon, if there's removal of estuary, quality to estuaries, and to your point, I guess, is it Lac Salam? I can't remember.
Lac Walams.
That was a good, important fight about the role of the estuary and the role of the health of the salmon and the kind of like the full life cycle. You've spent time up there, and just maybe share a few minutes about your experience. Like, is that like your relationship to birding, your relationship, you're a lawyer here in Musqueam, Slota, Squamish territory, but you're actually your passion for wild spaces, where did that come into your life?
I think that I grew up in a family that has a very close relationship to our territory. We grew up canning fish. We rely on the salmon. I have aunts and uncles that go out on our territory and get all sorts of different species, and we have a very close relationship to those. And so I've seen the ways in which that relationship may have changed over time as well, perhaps not for the better. We've seen declines in salmon and the health of our ecosystem. So I think I was raised certainly to be attuned to these things and to care about them. I deeply care about the environment in general, but more specifically, I really love the Skeena River estuary. I love where I'm from. I love where I was born, and I know it quite well, and I deeply care about its health. So I think that a lot of certainly my passion is rooted in that kind of familial and personal connection to that place. But I can't say my birding comes from there, because I worked as an adventure guide in Gitga'at territory, which is a part of the larger Tsimshian group. I think our main things, this is tongue in cheek, but it was a fishing guide. And I think the number one mandate was run over the murrelets, because they know where the fish are. We never ran over any murrelets. No murrelets were harmed. But it just goes to show, when you're in that space, you're so closely connected with all of those other animals there, and it tells you a lot about the place that you're in to be in such close relationship. Perhaps I'll end off on some of the just some tidbits that people might get entertained about, and bring in some the Semitic language. So the word for bird is tsu'uts in our language, and birds are so deeply ingrained within Ko-Tsimshian mythology. So obviously, with our clan system. So when I introduce myself, we have Ganhada, which is the Raven clan. We also have Laskik, which is the Eagle clan. So in our clan system, birds are well represented. And then, of course, in our oral traditions, a lot of our oral traditions are quite expansive. We have a lot of different aspects of it, but one of the more entertaining kind of folktale aspects of it is, of course, the Raven Trickster, which is common amongst the coast. But our word for the trickster is tchampsum. He transforms into a raven, and he has relationships with all sorts of different things. A lot of how we know about different markings on certain birds come from those tales. So Tramsum, he fought with, so Oolakins are some listeners might be familiar, but Oolakins are kind of an Arctic fish that spawn in the river systems in the kind of early spring. And Tramsum fought with a mew gull, and that's how the mew gull got its black tips on its wings, because they were fighting over it and tussling in the fire. Lots of different ways in which birds are well represented in our oral traditions and that kind of thing. And yeah, it's really, I get a lot of entertainment out of that to see that. And someday, I have it on my list, I want to write a paper that talks about all of these, like birds in Tsimshian mythology, because there's so many examples where birds play a really actually quite important role in guiding our worldview, which is, I can say without a shadow of doubt, is absolutely true today. You know, I'm an avid birder myself, and you know, Siobhan and I are proper weekend warriors. We're out there every weekend, I can tell you, and you know, it's still an aspect of our culture in a contemporary way. You know, like we're still out there looking. We still enjoy kind of the thrill of the chase, and it's yeah, like what in my view, what and we acknowledge the ancestors where we go. So sometimes when we're out doing these things, you know, we perform ceremonies that may or may not be connected to birding, but you know, we acknowledge the ancestors of the place, and you know, we acknowledge all sorts of different things. And so it's part of a larger practice of just getting outside. And you know, a lawyer, I sit at a desk often, and it's good to breathe the fresh air. So Maplewood Flats is a place that I do that often. So I'm very grateful for that.
Yeah, yeah, and I think what we're creating with Tsleil-Waututh at Maplewood Flats is a, I mean, we started this. You talked about the kind of constitution or the mandate of Raven, and the constitution and mandate of Wild Bird Trust is quite unique in the conservation sector, because it includes reconciliation and education about reconciliation. So we haven't separated and siloed this conversation. So we really want folks to visit Maplewood Flats and to understand and learn about Tsleil-Waututh knowledge, and see that as not something that can be separated from your birding experience. That those two things are the same. And you know, we're only starting that work. We're doing it very humbly, because it's very, very early days. You know, when we quote unquote saved Maplewood Flats for a bird sanctuary, we stole it from the Tsleil-Waututh for the second time. So that's a relationship we need to repair. Leonard George asked for the lands in 1971, that's 50 years ago, to be a site where Tsleil-Waututh children could grow up. And now we're only starting that work. That's 50 years later. So it's humbling to think about, you know, Leonard George's worldview about how he had to kind of experience that alienation from Maplewood Flats. What are some other, I mean, you know, when you think about the leadership you provide, Raven, what are some other ways when you think about Maplewood Flats that people could maybe kind of blur that understanding between birds and ornithology and learning about nature? You talked about your partner, she loves the plants. What are some other ways that kind of you might think that when you think about the people who support Raven might walk on the land and learn a bit of a broader sense of ornithology in a different context?
Yeah, and I think that last term that you used there is perhaps an operative one, is context, right? So you know, birding as an activity is, you know, you're there looking to, and it's a great, super fun and exciting hobby, and I partake as often as I can. But you can also, you can do other, that's the magic of birding. You can do other things while you're birding. You can, it brings you to very interesting places, which I suppose, you know, might raise an issue of consent, right? So this idea that there are sometimes very ecologically sensitive areas that it may not be appropriate for kind of you to, you know, just kind of walk through, or they could be, you know, sacred sites or whichever. And so that's just important, I guess, to consider, right? You know, if you're not kind of already alive to that, is that, you know, is on whose land are you walking, right? And, you know, and sometimes if it's a rich site for birds, or if it's a rich site for, you know, wildlife, chances are that it has a strong relationship to an Indigenous presence. You know, a lot of these places that we go to, you know, were at one point village sites, or still are village sites. And so, you know, that's something to consider. Some question I consider is, you know, why isn't it a village site now? You know, if it was historically, where's the village? There's a really compelling answer to that question, if you're willing to learn. And I understand, so tying it directly to Maplewood Flats is, I don't have any kind of privileged knowledge about that place. I went there as just kind of someone who wanted to check it out. I knew there was a lot of, my birding hobby brought me there. And, but what really struck me was kind of the other aspects to that place. It's really, I was struck by the art. I was struck by, the history, the activities that are going on there. And the more that I've learned about it, the more certainly that I've come to understand, in fact, the actual community that's there, right? And I understand that there's perhaps other goals and aspirations, things that you want to build out. But certainly, it's great to see that process is ongoing, because I think that that's so important. And yeah, and if birding can open up that door, then that's absolutely fantastic. And yeah, that's probably what I would say about that.
Yeah, I was thinking about the last week I saw a short-eared owl in Tsawwassen territory, but I also saw like 30 people taking its photo.
Sure,
and
yeah.
like the ethics of that is one thing, but also in terms of the ethics of learning about birds, and we're supporting the campaign around the falcon nests in Abbotsford, because there it's not just about saving falcon nests, it's recognizing, doing a bit of homework and going, actually the Chiam Nation was opposed to the expansion of that quarry that is threatening the falcon's nest, right? So for us, it's not just, oh, let's save falcons. It's actually, let's respect the Chiam Nation's aspirations that have been so far ignored by the BC government around protecting and saying enough is enough, no more quarries in their traditional lands. So I think that's another example where we can look at even the Site C issue in the West Moberly, the work that Raven is doing around fundraising, and say, short-ear owls are also threatened there, at risk there. And so looking at not just the beautiful birds that we're privileged to witness in these habitats, but to your point, is to think about what was here before. And I think that's where place-based approaches are really critical. If that there isn't a cookie cutter, we really do have to do the investigations, just like we're passionate about different bird species. We also have to think about where am I and what was here before, whether it's a pathway or a birding area or a designated this or designated that or conservation area, who made that declaration, and what's the role of the First Nations community. So yeah, it's been a great conversation. We covered a lot of ground. We deep dived into some legal principles, and we talked a little bit about the work of Raven and the work of Wildbird Trust. I really want to honor the fact that you work with a group of volunteers and staff, and I do as well. We're privileged to have this kind of community. You talked about the word community.
Yeah.
And I think that there's a community also that really could grow between Raven Trust and the Wildbird Trust, because I think what you're speaking about and what I'm speaking about, what we're sharing today at the Fireside, is that there's these underpinning issues around Indigenous justice and Indigenous rights to land. And we can be fans of ornithology and other activities in nature, but if we're not grounding it in a recognition of Indigenous lands and Indigenous title, then we're kind of just getting kind of a settler view without the full spectrum understanding of the birds in their context.
Yeah, absolutely. Well, I certainly echo that. I really appreciate the opportunity to speak with you today and participate at the Fireside. I too would like to acknowledge the community of Raven. We have some fantastic staff, great volunteers, and certainly an amazing community that really contributes to some quite remarkable work that I'm certainly, for one, quite proud of. So it's truly an honor to kind of wear that hat in the conversation and bring some of that knowledge to this community as well, and have some of that cross-pollination, because I certainly share that sentiment. It's always a great thing to connect in ways and share experiences and share best practices, and because the book isn't written on these issues, and it's for it that mantle is for us to take on, And we need to learn how to do it from our own respective areas. And maybe a teaching that I can share to kind of end things off that is like people can carry with them is, because like the kind of ground floor absolute kind of bare minimum is sometimes thought of like the land acknowledgement. And I know there's like some people that problematize that, and for good reason. One of the teachings that I received was, whenever you do a land acknowledgement, think about how it's relevant to the activity that you're doing in the moment. And so perhaps on that spirit of that question you asked, maybe next time you're birding, acknowledge the place in which you're in, like really kind of, and introduce yourself, right? You don't have to leave who you are as a doer, quite the opposite, right? Like come with respect and acknowledge, like take stock of that and figure out what that means, and just reflect on it yourself. And I think that sometimes certain lights can go off, or connections will be made, because that's a practice that I personally do, and Siobhan does as well. We thank the bird whenever we see a new bird or a particularly rare bird. We say a little prayer and say, hey, thanks, because it forms a relationship, right? When you get that special experience, and go in gratitude and go in respect. So that's a little teaching perhaps I can share to end things off. And I'm very grateful to have participated today.
Did good. Thanks very much. And folks can visit Raven Trust. Is it raventrust.ca?
I should know. We just got a new website. So Raven.
It's raventrust.com. Raventrust.com.
Yep.
And
there you go.
Of course, it's wildbirdtrust.org. And yeah, I'm just wearing your swag here. So
look at that.
Proud fan of Raven Trust, and I encourage the Wildbird Trust members as well to donate and support the great Indigenous land campaigns that Raven Trust is building bank accounts for and helping resource. So it's a great way to be a settler, be a migrant here on unceded lands in British Columbia. Thanks very much, Jeffrey.
Thank you.
So just